to the second part of Landmark Chambers seminar, Climate Change and Human Rights. My name's Fiona Scolding, KC. I will be chairing the session today, and so I will ask all of you to send in all your questions, because this is an area I know of hot importance to all of us who work in this area of law, and is of kind of national and international importance as well. And I can't think of three better people to be able to answer your questions than Reuben Taylor KC, James Maurici KC, and Heather Sargent, all of whom have formidable and long track records of specialising in this area. Just over to the first speaker of this evening, Reuben Taylor KC, a previous head of Chambers. He has been involved and is currently involved in lots of litigation which raises issues around climate change. He's currently awaiting a decision on permission for a case to go to the Supreme Court in respect of Boswell about the issue of cumulative carbon impact assessment. He is also, some might say, the king of the road, currently undertaking climate change challenges to the A38, the A12, the A66, and last but by no means least, the long-going issue of the Stonehenge bypass, nearly as long as the Heathrow litigation. Our second speaker this evening is James Maurici KC. He will be well known to all of you as an expert in all areas of planning and environmental law. Most importantly, maybe for these purposes, he was lead counsel for the Department of Transport in what seemed to be the never-ending Heathrow litigation, which involved a number of issues about climate change and carbon emissions. Last but by no means least is Heather Sargent, who is one of Planning Magazine's 2024's Women of Influence, and is the fourth highest rated junior planning barrister in the Planning Law Survey 2023. Most saliently for these purposes, she acted for Marks and Spencer's in their appeal to the High Court in respect of their redevelopment of the flagship Marble Arch Oxford Street store, and as a result of that is currently advising on carbon retrofit issues on several other London redevelopments. So after that introduction, I now pass over to Reuben, who's going to talk to us about domestic cases where issues of climate change have been raised. Thank you.
Thank you, Fiona. I'm going to talk through, I think I've got 9 cases to talk to you about. I'll try and keep it as crisp and as clean as I can. I think I first dealt with climate change as an issue back in the early 90s. We had to deal with the climate change implications of Terminal 5. Obviously a very different legal and policy framework in those days, and far less of an issue. I think we spent about half a day on it out of the 525 sitting days at that inquiry, to put it in some kind of context. These are the cases I'm going to be taking you to. They're all from the last 4 years or so, and they all relate to different elements of how public law is interfaced with climate change issues. The first is the Client Earth case from 2020. That related to a challenge to the DCO for the construction of 2 gas-fired generating units at the Drax power station. The Secretary of State's decision was against the recommendation of the examining panel, and the challenge to the grant of that DCO was unsuccessful. There are a number of grounds, the last of which actually related to the Secretary of State's consideration of the net zero target. You'll remember that prior to net zero, there was an 80% target enshrined in Section 1 of the Climate Change Act 2008. And the change to that target happened whilst the Drax DCO was being considered at examination. And the essential ground that was pursued was that there had been insufficient consideration of the implications of the adoption of net zero against the NPS, or NPSs I should say, which applied at that time. And it was said that in essence, as a result of the adoption of a net zero target, granting this DCO would lead to a breach of Section 1 of the Climate Change Act, the duty to achieve net zero, and there would be incompatibility with that target. The matter came before Mr. Justice Holgate. I think it's possibly his first brush with climate change. He's had many more since, as we'll see. But he concluded that, in essence, these issues were all matters of judgment for the Secretary of State to determine. And as such, a legal challenge could only be upheld if the judgment reached was irrational. And he concluded that that was not the case in that particular instance. And indeed, that is a finding that he repeats in a number of subsequent decisions with similar sorts of challenges. The next case I wanted to refer to is one that James Maurici will be very familiar with, the Prince of the Earth case, and that was a challenge to the adoption of the airport's NPS, which followed the very long process of the airport's commission. I was acting for Gatwick during that process, so this particular NPS it didn't find particular favour with my clients, but nevertheless they didn't challenge it. The challenge was brought by Friends of the Earth, and in essence in that litigation there was a bit of a flip-flopping depending on what level of court we're at. By the time the matter got to the Court of Appeal, the Court of Appeal was satisfied that in fact the adoption of the airport's NPS was unlawful. They declared that, and indeed that it was of no legal effect. Heathrow then appealed to the Supreme Court, and the Supreme Court, as you probably know, reversed the Court of Appeal's decision. A central issue in that particular case turned upon whether the Paris Agreement was actually part of government policy or not, and indeed whether various statements made by ministers in a very informal way were formally part of government policy. The Supreme Court analysed very carefully what was meant by policy in the context of the Planning Act 2008 and the legislation, particularly the phraseology in Section 104, and determined that even though the Paris Agreement had been ratified by the UK, that didn't render that treaty a part of UK law, so it doesn't give rise to legal rights or obligations in domestic law. There's quite a similar point that arises in the A303 litigation relating to whether or not there's granting consent for the tunnel to the south of Stonehenge. Actually gives rise to a breach of the World Heritage Convention, and there's quite an interesting discussion of that in the first of the Stonehenge decision, where Holgate actually says that there was no breach, and reaches very similar conclusions about the way in which international obligations form part of UK law. The Friends of the Earth case also clarified the position in relation to some material consideration, and there's an important element of that decision clarifies that in a situation where a decision maker effectively has a discretion as to what matters they take into account, an error of law will occur where a matter is omitted from consideration, where it would be irrational to omit that matter. And that is a test which is now routinely applied as a matter of public law. It's an issue which arises in many of the subsequent climate change cases, not least the most recent dismissal by Holgate of the second Stonehenge challenge, where numerous matters were raised and identified as not being material considerations because there was no irrationality. Finally, in relation to Friends of the Earth, the Supreme Court concluded that in any event, Secretary of State had in fact taken the Paris Agreement into account, and that meant that the only basis for a legal challenge would be if the weight ascribed to it was irrational, and the court determined that the weight ascribed was not irrational. Packham is the next case. This was a somewhat unusual challenge in that it wasn't a challenge to a DCO or any kind of development consent. It was a challenge to the government's decision to actually proceed with the HS2 project following Doug Okavy's review. And the central climate change issue that arose in that challenge was whether the government erred in law by failing to take into account the effect of the project on greenhouse gas emissions between that particular point in time and 2050. Of course, that was relevant because by this point in time, the Climate Change Act had set up the process of carbon budgets, the 5-yearly budgets, and some of them had been adopted by that stage. I don't think we got to the 6th carbon budget, but certainly up to the 5th by the point at which this litigation happened. And so the question was, had there been any assessment of the carbon implications of constructing HS2 in that period against those carbon budgets? And the court examined very carefully the nature of the decision being taken and drew a very significant distinction between the decision to proceed with the project and the sorts of decision that we tend to be involved in, the DCO decision, the development control decision, and determined that in the context of the brief that Doug Okavy had been provided and the decision that was being taken, sufficient account had been taken of the likely consequences of constructing HS2 for the government's policy on climate change and indeed for the purposes of the Climate Change Act. The next case I want to talk about, or two cases rather, is the Bristol Airport challenge and the case of Dawes. Bristol is another case that stings somewhat because I represented North Somerset Council in trying to stop that particular scheme from coming forward. But I'm happy to say I wasn't involved in the challenge. In essence, a local anti-airport expansion group challenged the grant of that particular planning permission. The planning permission sought was to extend, or rather to allow an expansion of Bristol Airport by 2 million passengers per annum. MPPA is the jargon that's used in airport planning for millions of passengers per annum. And the challenge was founded upon a number of grounds, including failure to have regard to a local carbon budget which the council had produced. And that is a theme, assessment against local carbon budgets, which has arisen in a number of other cases, particularly in relation to roads. I know that there was a point taken on the challenge to the A428 Black Cat Junction scheme, and also one raised in one of the earlier A47 schemes, which is the subject of the Boswell litigation. In Bristol, however, the court concluded that the local carbon budget was taken into account, so it wasn't left out of account. The question then becomes, as a matter of law, was the weight given to it irrational? The decision maker gave the local budget no weight, and Mr. Justice Lane concluded that that wasn't irrational, since local budgets have no basis in either law or policy, which is quite a stark statement. But actually, when you think about it, what is the basis on which you could ration a carbon budget? If you've got a carbon budget for a particular 5-year period of time, how can you determine within a geographical region how much of that budget is to be ascribed to that particular region? it might be a region, for example, that has particular industrial importance, and therefore on a national basis might be ascribed a bit more of the budget than, say, an area that doesn't have that particular output. So ascribing simply on a per capita basis or an area basis might not reflect the priorities of government. There have been attempts by, I think there's one famous attempt by Manchester University to produce local budgets on a basis that's proportionate by population, but it doesn't address that issue that I've just identified. And so that was the argument that was put, and which Lane accepted in Bristol Airport. And indeed, the other cases I mentioned before, none of those were successful at establishing there was any area of law associated with the consideration of local budgets. Now, having said that, there is actually, at the moment, an issue potentially on the horizon about local carbon budgets, because in the transport decarbonisation plan, the government's identified that some local transport plans in the future may need to include local carbon budgets, at least for the transport. I've been waiting for a while to see where that goes. I thought it might have died because nothing's been done. But in the response to the CCC's report last year to Parliament, the government's again mentioned them and says that they will be consulting on that process soon. Quite what that's going to involve, how they're going to calculate what the budgets are, I see that as a particular thorny issue. I suspect that once the government thinks about it really hard, they might actually walk away from the idea altogether. Dawes is the next case. That was a challenge to the decision to reopen Manston Airport, the Great Airport. And the central issue in that case turned upon the consideration of climate change and carbon emissions that were set out in the Jet Zero policy, which is the carbon decarbonisation policy for airports. And at the back of that particular document, there's an appendix in which the government sets out a series of assumptions about the growth of various airports across the country, calculates the amount of carbon that will be produced over time from those airports, assuming that they expand in line with their current plans. In other words, if the airports meet the demand that they're anticipating, here's the carbon they produce. And then using that amount of carbon, the government goes on to explain how that sits within the framework for its climate change obligations. In other words, Jet Zero is predicated upon assuming that the airports expand in line with demand. The CCC had previously suggested, and indeed continued to, as they did in their report last year, suggest that actually aviation demand cannot be met consistent with attaining budgets and net zero, and we need to cap demand so that, in effect, ration air transport, and that has its implications for those wanting to go on cheap flights abroad for their holidays from Luton and elsewhere. In this particular case, what was argued was that Manston wasn't included in the table, and so therefore wasn't taken into account in Jet Zero policy. So the Secretary of State couldn't rationally conclude that the grant of the consent from Manston was consistent with carbon budgets, whilst not affecting aviation demand. And the court in that particular case was taken to the conclusion that the Secretary of State reached, which was that because the carbon budgets wouldn't be affected and aviation demand could still be met, climate change was a neutral issue. The court decided that that wasn't irrational. It was a matter of judgment that So that judgment could be rationally reached, and so there's no error of law. The next case is Finch, and I'm very, very pleased I'm not involved in this case. This is a real head scratcher. The issue is about whether there's a requirement in the EIA to assess downstream greenhouse gas emissions as indirect effects, even though the permission in that case was for oil extraction and refining. So if you extract the oil, do you have to then take into account the greenhouse gas emissions that might result once that oil is processed in some other way? That matter was argued in June 2023, and we're still waiting for a judgment. So obviously not just me that thinks it's a difficult one to answer. There were quite interestingly different approaches taken to the legal context for that issue between the High Court, David Holgate, and the Court of Appeal. The Court of Appeal essentially took a Wednesbury approach. It's effectively is the judgment irrational that you don't have to assess. And David Holgate took a much more analytical approach in another one of his very lengthy judgments. Lengthy but useful is always the way I say it, particularly if he's in the room. I'm aware that during the argument in the Supreme Court, the Wednesbury approach came in for some criticism from the judges. So we'll have to see where that goes. Obviously, that doesn't mean anything, particularly given that we've had so long since the argument. I see this as probably one of the hardest issues to resolve that's come before the courts for a very long time in this field. And the difficulty, I suspect, will be resolved by practical considerations. The difficulty is this, that if the appellants are correct, effects which are not direct are all indirect, and so have to be assessed, even if they can only arise as a result of an intermediate process, for example, the refinement to make fuel. That as a concept would make the EIA process very complicated indeed. Where do you draw the line? In essence, you can't if the appellant's argument is actually accepted. And it has implications not just for oil extraction, but for many, almost all other forms of development that give rise to greenhouse gas emissions. So back to airports, if I expand an airport, more people travel from the UK overseas than would otherwise be the case. Do I have to assess the impact of their carbon on the foreign carbon budgets as they land and drive their cars around in Spain or the US? Similarly, I've got an airport, more people arrive than would otherwise be the case. Do I have to assess those arriving in the UK, the impact of their carbon emissions on UK carbon budgets as an indirect effect? Does their additional demand for hire cars mean that there's more demand for cars than would otherwise be the case? And do I have to assess that implication? And then there's the petrol that they drive, or using EVs to make the job more easier in terms of assessment. But you can see immediately the practical difficulties of not being able to draw that line somewhere relatively sensible. It was that sort of practicality which, when you read the David Holgate's judgment, I think you can see he was entirely alive to. And for my part, I hope that the Supreme Court is similarly aware of the potential consequences, not just in relation to oil extraction, but generally for the assessment process system. Dunsfold is the next one. This is another gas extraction this time, test drilling at Loxley near Dunsfold. It was for a 3-year permission. It's the same applicant as was involved in Finch. They're not having much luck with their schemes, are they, at the moment? But the evidence at the appeal included greenhouse gas, climate change effects, but there wasn't much focus on those issues. There was a much greater focus by objectors on alleged conflict between gas extraction and national policy on net zero. The inspector concluded that energy resilience pending net zero provided sufficient justification for the scheme, and only given that it was only test drilling that they were considering about, the Secretary of State agreed and granted permission. On the same day that permission was granted, the Secretary of State refused permission for shale gas extraction at Ellesmere Port on the basis of greenhouse gases and climate change. And the amount of greenhouse gas for each of the schemes was very similar. So one of the grounds of challenge against the Dunsfold-Loxley scheme was that the Secretary of State hadn't properly considered the climate change issues, since it reached the opposite conclusion in the Ellesmere case. It's one of those cases about consistency in decision making. The judge decided that the challenge should be dismissed, and indeed the Court of Appeal refused permission to appeal. The judge distinguished the Ellesmere Port decision on the basis that climate change was a principal issue in that case, wasn't at Loxley. There was a different policy context, so conventional gas and shale gas, and also found a number of differences in terms of the nature of the site, the form of development. But in essence, and it was in essence those distinctions which meant that it wasn't a like-for-like case, and so the cases on consistency in decision making didn't apply. The Greenpeace decision, that's the next one. That was the challenge to the 33rd round of offshore oil and gas licensing plan, and this was in essence a sort of SEA type challenge. The central point was that there had been an omission of the consideration of the end use greenhouse gas emissions, that was unlawful, effectively the same point as in Finch. And in respect of that issue, the court identified that the legal test was whether the reasoning as to why end-use greenhouse gas emissions could be omitted was irrational. And the court concluded that it wasn't irrational to exclude those because the offshore energy plan doesn't set the framework for the use of petroleum products. You'll recall the case law about SEA and plans having to set a framework for later decision making in order for SEA to bite in that sort of way. And so it was lawful to conclude that greenhouse gas emissions from end use were not likely significant effects of a plan. Safer territory for me, which is also litigation I've been involved in from the outset. It's actually 3 separate judicial reviews rolled into one, challenging 3 DCO schemes for improvements to the A47. And the now only remaining issue is about whether the EIA assessment lawfully assessed cumulative carbon impacts. And to understand the point, the assessment process that was deployed by the highways agency, I was going to call them, showing my age, National Highways, is effectively the same in these schemes as it is in every road scheme. So this litigation has implications for every single road DCO that's currently out there. They follow an assessment process in a document snappily entitled LA114, which requires them to identify a future baseline, which includes traffic that between now and Oakland from local growth together with other development growth, which has a particular likelihood. And they identify from that the do minimum case, which is a future case, and they calculate the carbon emissions associated with that baseline. In the A47 schemes, they included carbon emissions from traffic that would travel on the particular stretch that they were looking for in each DCO from the other DCOs. They then identify a second scenario, they do something, which is the baseline plus the traffic associated with the individual DCO scheme. They calculate the carbon emissions for both of those scenarios. The carbon emissions for each scheme, I should say alone, not a lump. I'm not quite sure how my fingers managed to press F, not E there. The carbon emissions for each scheme alone were assessed against carbon budgets. And so they took for each carbon period the emissions for the scheme individually, so do something minus do minimum, and assess that against carbon budgets, and identified tiny percentages that these schemes would represent for the total carbon budgets. Figures like 0.0009%, that sort of scale of things. In each case, the Secretary of State decided that that process amounted to a cumulative carbon impact assessment, and that given the scale of the emissions, each scheme was unlikely to materially affect the government's ability to achieve its carbon reduction objectives. The claimant challenged on the basis that it wasn't a cumulative carbon impact assessment because all that's been assessed is the emissions from the scheme. But that argument has not found favour either for Justice Thornton or indeed for appeal, both courts holding that the Secretary of State had acted lawfully, if not ideally. In essence, they've concluded that an assessment of the scheme emissions against the carbon budgets is a cumulative assessment because the carbon budgets represent the total amount of carbon which is lawfully permissible in the UK. And so you're assessing against a cumulative comparator. Another important aspect here was that it was recognised that the receptor for carbon emissions from these schemes is the planet as a whole. And so the argument that you should select and add in other developments alongside the scheme itself, which you then compare against the carbon budgets, gives rise to a certain element of arbitrariness. Why would you add just the adjacent A47 schemes? Why not take the scheme in Oxfordshire that's being done and amalgamate that with the A47 in Norfolk, or indeed, why not do the motorway that's being built in France or China? And that the courts at both levels recognised the arbitrariness of what the claimant was arguing, and indeed recognised too that the claimant hadn't identified how you identify which schemes you add. Where's the line that's drawn? Having said that, permission to appeal to the Supreme Court's been sought quite recently by the appellant, and we wait and see whether this is the sort of issue that the Supreme Court wants to address. So where do I get to in terms of these recent cases in human rights? Well, what you can see immediately is there's a striking absence of any substantive convention points other than some Article 6 points from recent climate change cases. That's potentially because there's been no real attempt to use Article 8 in the UK to pursue an environmental agenda. Perhaps that's because of the outcome in the Hatton case. That was the noise, the night noise case against Heathrow that was brought many years ago. There's been no successful case to date to establish that the Secretary of State is moving more quickly to establish net zero, despite it being government policy and embodied in legislation. All of the cases turn on the assessment of climate change impacts and what should be assessed and the judgments that are to be reached in balancing the various policies with net zero objectives. And there's still uncertainty about the scope of EIA in that regard. Boswell is an example of that, and Finch, of course. There is an acknowledgement by the courts, I think, in almost all of those cases, if not all of them, that in this particular area where you're looking at development consent issues, there are legitimate policy objectives for the Secretary of State to pursue that mean that some carbon may be inevitably produced. And it seems to me that the courts are likely to be reluctant to use the convention to engage in this highly politicised decision-making field. And I think also, for my part, I think there's quite a stark factual contrast with Switzerland. We have the CCA, we have carbon budgets, we have a raft of policies that have been adopted. Some of those have been quashed, some are still under challenge. It's a very different factual background to the position that one sees in the Swiss case. I think that's likely to be the focus for the debate that's inevitably going to come. I'm just waiting for my first convention claim on one of the road schemes that no doubt will be coming my way in the next few weeks. But we'll wait and see.
Thank you very much. Because Heather has some issues that mean she has to get away a bit earlier, we're in fact going to put Heather next, if that's okay. So Heather's going to be talking to us about Marks and Spencer's and not Percy Pigs or anything involving those.
Thanks, Fiona, and yeah, if I can get the clicker to work. Yes, the aspect of planning and climate change that I'm going to focus on, as Fiona mentioned, is the retrofitting debate, and particularly what the latest is on that in the light of the recent High Court decision in the Marks and Spencer's case. So the background to Marks and Spencer, for anybody that isn't up to speed with that, is that Marks and Spencer have applied for planning permission to redevelop their flagship Marble Arch store on Oxford Street. There was no objection to their proposals from Westminster, the local planning authority, or the Mayor of London, but the application was called in by Michael Gove for determination by him. There was an inquiry in October and November 2022, at which Save Britain's Heritage objected to the application, but on grounds not only relating to heritage, but also relating to the carbon impact of the scheme, and they participated in the inquiry. The inspector was David Nicholson. He reported at the beginning of February last year, and his recommendation was that the application should be approved and planning permission granted. But Michael Gove took a different view, and in July last year refused the application. Marks and Spencer brought a statutory challenge to that refusal in the High Court, and on the 1st of March, Mrs Justice Leven quashed the Secretary of State's decision letter and upheld the challenge on 5 of the 6 grounds that had been put forward by Marks and Spencer. So the Secretary of State now will need to redetermine the application, and at the moment that is being dealt with by way of written reps. Just to set the scene in carbon terms for anyone who isn't familiar with the terms on the right. There are no shortage of different definitions for this, but in broad terms, embodied carbon includes carbon that's released from the demolition of any existing building on a site, carbon in the production of the materials for the new building and in the transportation of those materials, obviously carbon emitted in the construction of the new building and also in the disposal of the material at the end of the building's life, whereas operational carbon is carbon emissions from the use of the building post-construction on things like heating and cooling. That also does then split into regulated and unregulated emissions, but I think for this afternoon's purposes we can dispense with considering that in more detail. But then whole life carbon, as the name suggests, encompasses both embodied and operational carbon. The graphic on the left is the result of me having lost an argument with my laptop last night. There was a nicer version, but I gave up and decided to resort to a Sharpie and some highlighters. But the point that it's trying to make is a simple one, which is that in the initial years of a development's life, a new build option may well be more carbon intensive and starts off being heavier performing in carbon terms than a refurbishment. But over the lifetime of a development, it's possible that a new build option can catch up and then overtake refurbishment options, because the operational performance of a new build may well be more efficient in carbon terms than a refurb. And also for other considerations, such as if you've got a refurb scheme, you might find that you need to do a second and maybe a third refurbishment sooner than you would do if you've brought forward a new build. Turning to what happened in Marks and Spencer and beginning with the inspector's report, as you can see here, the 2 points that I need to draw out from this for discussion this afternoon are, first of all, the identification from the inspector that there should, in his view, generally be a strong presumption in favour of repurposing and reusing buildings, although he does go on to say that although there should be such a strong presumption, it depends on a number of things, but particularly whether or not there's any reasonable prospect of an alternative scheme going ahead. And his conclusion on the facts was that there wasn't an alternative scheme that could be delivered, although the Secretary of State didn't agree with that. But the other aspect that's relevant to the carbon and climate change debate is the point at the bottom there, which was that factually the inspector, as you'll see wrongly, but he understood there to be no dispute between the parties that redevelopment would involve much greater embodied carbon than refurbishment. Turning to Michael Gove's reasoning, as you'll see again at paragraph 21, he picks up both of those points. So he also identifies an alleged agreement that redevelopment would involve much greater embodied carbon than refurbishment. And importantly, this then went on to form ground one of the High Court challenge, agreed with the inspector that there should generally be a strong presumption in favour of repurposing and reusing buildings, and found that in paragraph 152 of the National Planning Policy Framework. Here is what that paragraph actually says. It's now paragraph 157, and this is the first paragraph in chapter 14 under the heading Meeting the Challenge of Climate Change, Flooding and Coastal Change. But as you can see, there's a reference to encouraging the reuse of existing resources, including the conversion of existing buildings, but no express reference to a presumption, still less to any strong presumption. So it was that earlier this year, in relation to ground one, Mrs. Justice Leven, in no uncertain terms, held that the Secretary of State had plainly interpreted the NPPF and erred in law. He hadn't applied the policy, he had rewritten it. And as she notes, there's some encouragement for the reuse of buildings in paragraph 152, but nothing that comes close to a presumption. The other point that I just want to draw out as well here, and we'll come back to this later, but this is a decision tree from the Mayor of London's London Plan Guidance on Circular Economy Statements. So slightly peculiarly, it's a separate document for the whole life cycle carbon guidance. In the High Court, SAVE argued that this was where the inspector, rather than the Secretary of State, but the argument was that the inspector had found his strong presumption essentially as a summary of the approach that's set out in this decision tree. Mrs. Justice Leven, because that wasn't the reasoning that the Secretary of State had deployed, didn't reach a sort of firm conclusion on this, but she did note in terms that, again, this guidance document doesn't say either in terms that there is a strong presumption. And she went on to say that it may be questioned whether this guidance document could give rise to a strong presumption, but in any event, that wasn't the approach that the Secretary of State had taken. So question mark, I think, at least over whether in the Mayor's guidance there's a strong presumption, but at any rate, certainly not one in national policy at the moment. Returning to the error of fact aspect of the High Court decision, The background to that was that the scheme architect for Marks and Spencer's had considered and ruled out all sort of alternative options, so including a light touch refurbishment and facade retention. SAVE had also ruled out a light touch refurbishment and facade retention, but then very late in the inquiry, they did put forward an outline of a comprehensive refurbishment option, which in their view was a sound alternative to complete demolition. And in the High Court, Marks and Spencer argued successfully that the Secretary of State and the Inspector had gone wrong in identifying that there wasn't any dispute as to whether redevelopment, so the new build option, would involve greater embodied carbon than the refurbishment option, because as Justice Leven held, there had been a disagreement on that point. But the point that I just wanted to consider in more detail actually is this remark from the judge at paragraph 110, where she says, as a very general proposition, it's obvious that a refurbishment may well involve less carbon than a redevelopment, but that tells one nothing about the facts of this case and the carbon impacts of a deep refurb. I think, in my view, the emphasis here needs to be on very general and on the point about it being, possible that a refurbishment may well involve less carbon than a redevelopment. As the judges acknowledged, in my view correctly, whether that proposition holds good will depend on the facts of the case. So what's on site already, what's the existing building that you would be looking to refurbish, and to what extent does it lend itself to a retrofit or to a refurbishment as opposed to demolition and new build. And in terms of any more general proposition, one of the difficulties facing everyone involved in the retrofit debate at the moment is that it's a debate that's relatively recent. It's only been at the forefront of people's thinking in the last, well, I'm sure for some people it's been at the forefront of their thinking for a long time, but to a broader pool of people, it's the last couple of years that it's really come to the front. So the data, for example, on the embodied carbon performance of different types of development, such as a light touch refurbishment as opposed to a heavier refurbishment, has been limited, and that data is being generated as more and more schemes come forward. The latest analysis that I've seen indicates, as you'd expect, that for the different types of redevelopment, there's a range in terms of the embodied carbon that you can expect to be generated, and actually there is significant overlap between the ranges. So it's not as simple as simply saying, well, a refurbishment's going to be better in embodied carbon terms than a new build, because the emerging data probably as a very general proposition does support that, but on a more detailed analysis, the position is more nuanced. So turning from the M&S case just to look at where we've got to with current and emerging policy and guidance, this is the policy in the London plan. So it states that major development should be net zero carbon, and then Part C deals with the percentages that are to be achieved and introduces the possibility of making an offset payment. Another aspect that did emerge from the Marks and Spencer's judgment is that SI2C is talking about operational carbon, so it's not dealing with embodied carbon when it's discussing offset payments. But beyond that, SI2E is a requirement to minimise unregulated carbon emissions, and then the requirement in relation to whole life cycle carbon emissions in the policy is to calculate them and to demonstrate actions taken to reduce them. And there's then policy SI7 that deals with the circular economy. But nobody, significantly in the Marks and Spencer litigation, no one was suggesting that policy SI2 or SI7 include any strong presumption in favour of the retention of buildings. So that's where essentially the position has got to nationally and also in London at the strategic level. What I think is interesting is the shift that is happening at the local level, certainly in London, and people who are listening in might have similar experiences elsewhere. But the first example of this was the City of London's December 2023 SPD. So again, to begin with, and at the moment we're still in guidance rather than policy. But that set out a retrofit first approach, although you'll see here it essentially refers to the circular economy statement guidance. So in effect, it's founding itself and aligning itself with the decision tree that we looked at earlier. So that was the initial approach taken by the City of London. They, I think 5 days ago, launched their consultation on their Regulation 19 plan, which includes, I think, 23 references to retrofitting, at least if my PDF reader was right. And you can see the approach here. It's come particularly in 2 policies on design, explaining that a retrofit first approach is to be taken, but relatively high level. You'll see in contrast to the approach that's being proposed by Westminster, which I'll come to in a moment, a sort of high level requirement to follow the retrofit first approach and to explore options thoroughly. I should also mention the London Borough of Camden, which published its Regulation 18 plan in January this year, and similarly a kind of high level approach as the City of London are proposing. Camden are proposing to require applicants to undertake a feasibility assessment to demonstrate that retrofit and refurbishment have been explored before demolition is pursued. Then coming on to Westminster, they are currently, the consultation is about to conclude on this, I think, but they are currently consulting on their Regulation 19 for a partial review of their city plan. And this is the first part of their proposed retrofit first policy. And as you'll see from the sentence that I've highlighted, they are proposing to have a policy of generally resisting total demolition of buildings more than single story high. Just before we come on to the detailed criteria through which that is avoided, it's interesting to note that they are going so far as to identify in their glossary the percentage terms past which you will be a retrofit or a substantial demolition, and also that facade retention seems to be encompassed within the total demolition category. So really quite a detailed approach proposed by Westminster. This then is picking up the remainder of, and the policy does continue beyond this, it's very lengthy, this is just the first part of it, but looking at the tests that have to be passed in order to discharge the retrofit first requirement. First of all, this does seem to me to be an obviously more demanding approach and a more detailed approach than the City of London are proposing. Next up, if anyone from the City of Westminster is listening, I think this sort of and or approach to drafting this policy is a headache that's immediately going to just confuse everyone. So if they could be encouraged to iron that out and make it clearer how you navigate 1, 2, 3 and 4, that would be helpful. But the other thing that I think isn't clear to me is if part 2 is satisfied, so if you have a new build proposal that would be similar, or particularly if you have a new build proposal that would be less carbon intensive in terms of the whole lifetime carbon, then why do you also need to satisfy part 1 of the policy? Because if you have a new build proposal that's the best performing option in carbon terms, then why would that option be counted out? Because the benefits could alternatively be delivered through a worse performing scheme in carbon terms. So I don't know, maybe someone listening in has the answer to that one, but I think overall, standing back from kind of the detail of this, the 3 London boroughs that I've mentioned are not the only ones who are proposing to introduce a retrofit first approach either in policy or in guidance. I saw some research from Lichfield that identifies a further 6 as already at that stage. So this, I think, probably does tie into some of what James is going to talk about around the dissenting judgment in the Swiss case, but also the concern around how democratic are the various methods through which the climate change agenda is being pursued at the moment. I think everyone can have their own view on the extent to which the local plan process is accurately described as democratic or undemocratic, but it seems to me, for what it's worth, that it's at least arguably more democratic than judges in Strasbourg just deciding, you know, what direction we should all be going in. So I do think it's interesting that at the local level in London, at least, there is a marked trend towards this retrofit first approach and towards focusing on at least addressing the carbon aspect of climate change. I think there's obviously a balance to be struck here, and I think striking that balance does present a number of challenges. So there's been significant reference in the commentary online to, well, it must be a retrofit first, not a retrofit only approach. Clearly in planning law terms, even if you were to have a policy that just said we are only supporting retrofit in our area and we won't permit any new buildings, that wouldn't be game over anyway, because that would still be a single policy, and you'd have to consider everything else as well. But I think the more demanding the wording of a retrofit first policy is, then the more likely it is that in real practical terms it might operate essentially as being retrofit only. And not to minimise the importance of tackling climate change at all, but it is obviously only one of extremely important considerations that the planning system has to grapple with. So I think that, you know, there are already lots of instances of successful retrofits that have worked really well, but I do think that there's a need to be careful with emerging policy that the way that it's drafted means that not just on paper but also in practice it can be applied in a way that applicants can successfully argue that for whatever reason retrofit isn't the answer for their site or their scheme. And in particular, I think there is a need to be careful to ensure that policies are worded with sufficient flexibility, so that where you do have a situation where retrofit isn't even the best performing option in carbon terms, then that can be recognised and that can be factored in through the decision-making process. So that's what I have for you on carbon and retrofitting.
Thank you very much, Heather. We now pass over, last but by no means least, to James, who's going to tell us all about Judge Ike's dissenting judgment in the, and I just have to say this, the Verein, Klimaseniorinnen, Schweiz and Switzerland, otherwise known as the Elderly Ladies of Switzerland case. James.
Yeah. So obviously we're back to I'm going to call it the Swiss case. We're back to the Swiss case, but I'm really approaching it from the perspective of what implications it might have domestically going forward in the case law. We have to start with the dissent itself. It packs a hell of a punch. These quotations, I think, give you some sense of that. Disagreement goes well beyond a mere difference in the assessment of the evidence or a minor difference as to the law. The disagreement is of a more fundamental nature, and at least in part goes to the very heart of the role of the court within the convention system and more generally, and in particular obviously in relation to the role the court has in dealing with climate change. And the conclusion is that the majority have gone, so Judge Ike says, well beyond what he considers to be permissible under international law. It doesn't stop there. He says the majority's judgment will give false hope that litigation can provide any kind of answer to the issues that we face on climate change, and perhaps worse, that having to deal with litigation of the nature that's been that it is going to be created by the majority's judgment, it will actually be a distraction rather than any kind of benefit towards other branches of government that are trying to allegedly at least deliver on climate change. And he says while he recognises the urgency of the climate change issue, the judgment is illegitimate and impermissible in terms of what the court has sought to do. Now, when I read the dissent, I started thinking about what is the purpose of a dissent, because it's such a fundamental dissent. One doesn't often see a dissent that's in quite such fundamental terms. And I came across a very interesting Lord Kerr's Birkenhead lecture on the nature of dissenting judgments, focused more on final domestic courts of appeal rather than international courts, and the very different views that are out there about what a dissent does. So Lord Kerr quotes first of all from Chief Justice Stone in the US, and I did like this one, that a dissent is an appeal to the brooding spirit of the law, to the intelligence of a future day when effectively things might be reversed in a future decision. I think Lord Brown had a much more realistic view about a dissent, which was that it's not really about the hope or expectation that the dissent will one day become the majority view, but rather that if you as a judge genuinely think the majority have got it wrong, you have an obligation to set out what your view is, even if you don't think it's going to have any chance of influencing the future progress of the law at all. Now, Lord Kerr, having looked at those views, comes with his own analysis. He says it's not the jewel in the crown of our system that we have dissents, but it's certainly a gem to be treasured. But what I thought was interesting, the bit that I've highlighted in red, the opportunity to dissent has never been more important than it is today. Since the coming into force of the Human Rights Act, decisions that judges must make in many cases are far less likely than in times past to be determined by their view of black letter law. Resolution of competing policy arguments or even moral choices is far more frequently the staple of judicial decision than previously, and judges must confront human rights cases of fundamental importance, often vital societal issues at stake. So, I mean, if you think about what we're about to talk about, that is obviously something that falls square within this. And again, he echoes judges should feel uninhibited to express those views. One effectively sees it as an element of almost like a democratic process that people can disagree. I think there's one other really important thing that a dissent does, and I think it's really important for the case we're talking about, and that is if you want to understand what the likely effect is going to be of the majority's judgment going forward, what a great place to start, but looking at the judge in the same court who's saying your judgment's going to have all these terrible consequences. So if you're looking for, what can we be using the Swiss case for? Actually, you can look at Ike's judgment, because he's actually telling you what he thinks all the consequences will be, i.e. giving you some clues for the future arguments for your Human Rights Act and climate change challenges. Now, I guess before I go any further, what is the actual impact of the dissent? What role does it have domestically in strict black law letter terms? Well, I mean, obviously, the case law of the court in Strasbourg isn't binding. It's something that has to be taken into account. So that's the majority view rather than the dissent. It's something that has to be taken into account. So obviously, our courts can depart from Strasbourg, but if you look at cases like Chester in the Supreme Court, where you've got a decision of a Grand Chamber, which of course we have here, it's only going to be in the most exceptional cases that the English courts will refuse to follow Strasbourg. Now, you might say, well, that means the dissent is of no real relevance, but I don't think so. Now, the dissent focuses on really three things. One is about the victim statement point, which I won't dwell on, because I don't think when one comes to how this plays out domestically, that is the most important thing that we are facing anyway at all. The second is what the court's role is in terms of evolution interpretation. And then thirdly, it's about the creation of a new right, which is a concern. Now, I think it is important to recall what is not the basis for the dissent. And that is quite important. What is not the basis for dissent? So first of all, no dissent on what the nature and the magnitude of the risks are that we challenge from climate change. Thank you. Thank you. No challenge to that. Secondly, no challenge that this is something that needs urgent action. And then thirdly, no challenge that we are talking about some very complex challenges. And also, interestingly, the judge didn't reach a different view on the outcome on Article 6, but only about the reasoning. Now, what did the judge say about the role in terms of evolutive interpretation? Well, the Convention, to start with, doesn't have a right to a healthy environment. There have been various attempts to include that, and they've all failed. And when the judge says this, and I think this is one of the really important parts of the dissent, there are enormous evidential and scientific complexities, and the query that is raised is, does the court actually have the ability to deal with those? So the question is, given how complex this is the court actually well placed to wade into this area? And is that approach not inconsistent with the approach the European Court's taken in other environmental cases where it's taken a very standoffish approach to complex issues? Now, the judge went on to say, it seems clear to me the court does not have the capacity to engage in anything approaching such a review process as is required by the majority's view. So that's the scientific complexities. But then in addition, there's also the question about whether the political complexities are such that the court shouldn't be stepping in to this area. Now, I think really another key part of the dissent is the strong disagreement with the majority's approach, which is effectively created, so the judge says. So this is, I think, where the dissent is useful in understanding what the effect of the majority's judgment does if you want to be using it in future cases. So it's created a new right for individuals to effective protection by the state from the serious adverse effects caused by the risks of climate change. So that's a very useful summary by the dissenting judge of what the majority has done. And it's created a new primary duty on the parties to adopt and to apply in practice regulations and measures capable of mitigating the existing and potentially irreversible future effects of climate change. Now, in addition, and this is, I think, where the judge again captures very kind of pithily what the majority have done, is not only is there this new right, new duty on the states, but the court have said, unlike in other areas, similar areas to this, there is effectively a reduced margin of appreciation for governments, and the only place where there is a larger margin of appreciation is the choice of means, including operational choices. But the actual commitment to combating climate change is going to be accorded a reduced margin of appreciation. So new right, new duty, and reduced margin of appreciation for the state. Those are, I think, an excellent summary of what the majority have done and what the implications are going forward. So the judge goes on to say compliance with either margin of appreciation will now be supervised by the court, and it's to be assumed not just by the court but by national courts and tribunals. So again, if you're looking at what the future implications are, is pushing you. This is not just something for Strasbourg. This is pushing a new role on the national courts, and they've got to undertake that assessment according to the criteria which the majority set out in paragraph 550. Now, where does that all take us? Well, obviously the conclusion of the judge is the majority went too far. They tried to run before they can walk, and they are going to create a major issue and headache going forward. So what are the concerns of the dissent? One is competence. Does the court actually, and does not just the Strasbourg court but our courts, have the competence and the expertise to make the assessments it's now required to make? Secondly, is it democratically legitimate for the courts to take this role? Thirdly, is the reduced margin of appreciation justified? And fourthly, will the majority's approach in fact hinder rather than help in the fight against climate change? Now, the first concern of the judge was whether the court was competent to make judgments that affected the majority's view, and I'm going to come to that in a moment. But the second concern is even more fundamental, and the judge emphasised that democratic decision-making has effectively been found to lie at the heart of the whole of the convention, and the question that he raises is whether the court is interfering with that by taking on this role. The third concern, obviously, then is in relation to the reduced margin of appreciation and how that is going to operate. And the fourth concern, as I've said, is whether it will help or hinder. Now, when you take that through, how is this going to impact on our courts? Well, I think the first thing to say is this is a dissent caused by the UK judge, and it seems to me his instincts on these issues may well align with the majority, if not all, of our own judges. And those concerns, competence of the courts, the new positive duties, the reduced margin of appreciation, the democratic legitimacy of the court taking this role, they reflect, it seems to me, very strong themes that exist in our own domestic law on climate change at the moment. And that this decision risks potentially upsetting those. Now, this is getting into very personal views. I did feel when I was writing this that I was writing a political speech, and then I thought, well, that's the court's fault rather than mine. So the issue on the democratic...
With a small p, which is fine.
Politics with a small p. The issue of democratic legitimacy is a difficult one. I mean, many people would say the court has stepped in because governments have failed. And it's very hard to argue with that on climate change. Governments have failed to tackle the issue quickly enough or effectively enough. And I don't think that's a surprise because, you know, democracy does seem in the modern world to be badly affected by political short-termism, and one needs a long view if you're going to combat something like climate change. The problem is, if the courts think they must step into the gap when governments fail, good luck to them, because at the moment that would seem to me to apply to almost everything that government does, not just climate change. Now, if you step into everything, you've got a problem. So, can I come back to the competence of the courts? Well, our courts have said there's a wide margin of discretion to decision makers where decisions turn on scientific, predictive and technical knowledge and expertise. And that's MOT, applied in numerous climate change cases as listed out here. Does the view of the majority threaten this? And is Judge Ike not right to ask the question, well, are the courts actually competent to deal with these issues? So my thoughts on how this may play out: I think the MOT approach, much hated by those who seek to challenge environmental decisions, because it really does make it much harder, must be open to at least a potential challenge in a Human Rights Act case now. There must be some room to push it in a climate change case to say that MOT is not the approach that one should take. But why stop at MOT? Why shouldn't it apply to other pressing environmental issues or other public law issues more generally? Now, there might be a tie-in here to other international law, which is we're all waiting, and I think it's about 4 years since the hearing now, for the Aarhus Compliance Committee to come back on whether Wednesbury Review is compliant under the Aarhus Convention, whether that's a good enough level of review. And that may well tie into this. I mean, if the committee ever actually makes a decision, which at the moment I'm not sure, because they seem to have such a backlog. But also, does the majority view bring back into focus an issue that we've debated in this country many times about whether we need an environmental court that has scientific as well as legal expertise? And I was thinking, well, do we actually need that at all? Because if you look at the civil procedure rules, there is a power for High Court judges to sit with technical assessors. Now, it doesn't happen in judicial review, but I'm not sure why it couldn't happen if that was felt to be what one needed. So one other matter then, the reaction, the effect of this domestically. Well, we had a very balanced response from the Secretary of State. I'm concerned by the decision how we tackle climate change affects our economic, energy and national security. Elected politicians are best placed to make those decisions. Well, Secretary of State would say that, wouldn't she? Joshua Rosenberg, commenting on it, said, well, look, there is a concern here. This is going to feed this debate that's going on about whether the UK should still be in the European Convention, although ultimately Joshua Rosenberg's view, which I agree with, is that there isn't really any realistic prospect of us leaving the convention, and nor will this tip us over the edge. But did that stop the reactions from some quarters? No, bonkers ruling, I like that. And then interestingly, I think what was quite interesting was that quite a lot of these articles did very much pray in aid Judge Ike's dissent in making the rather fervid points that were being made. And then I was sent this by someone who told me that I should look at it. Conservative Home, not somewhere I'd normally spend much time, but Conservative Home. And this is Richard Eakins, who's
That's your defence.
That's my defence. That's what I say here. Absurd climate change ruling, and then certain to launch a wave of climate change litigation. Well, probably true, but again, you should always look to the opponents of a decision to understand where it's going to take you, and they're actually telling you this is where we're going, a wave of climate change litigation. Again, very much drawing in Judge Ike's dissent and praying that in aid, talking about new invented obligations on the state and a reduced leeway, i.e. the margin of appreciation, for how they apply it. The leeway point, obviously, I think is perhaps more of a concern. Are we talking about reduced margin of appreciation? Then picks up on, is the court ill-equipped to deal with all of this, which we've talked about, and then says it helps seal the case for states to withdraw from the convention. Well, that might be pushing it a little bit, but that's the conclusion that's reached here. Jonathan Sumption, writing in the Sunday Times, also expressing concerns about the decision, really more from the democratic legitimacy perspective, which is interesting that there are these views out there. So back to the role of dissents. I found a really interesting speech that was actually part of the opening of Strasbourg court sittings in 2019, talking about dissents, because obviously what's interesting is the European Court of Human Rights allows dissents, and the European Court of Justice, as we know, never has. But of course, that's why we get those judgments from the European Court of Justice, which are a compromise and therefore don't really say anything at all, or anything that anyone can actually understand. And so actually one of the really important things about dissents is they do actually, I think, increase the transparency of the decision. You're allowed to see what the counter view is, and that counter view may help you understand the view of the majority and what the implications of the majority's judgment are. So where are we then? Are we entering the age of a rule by judges, which apparently, I didn't know this, I looked it up on Google, obviously, there is actually a name for this, critarchy or critocracy, or so there are various names for this, all apparently derived from Greek to mean rule by judges. Is that where we're heading? Probably not. But if we are, is that necessarily a bad thing? Well, it depends on your starting point, really. If you actually want things to happen on climate change, maybe not a bad thing, because it looks like courts are more prepared to do that than perhaps elected politicians. But I think what I am sure about is that we probably haven't heard the last, at least in our domestic courts, of the Ike dissent. It may not call out throughout all time as some of these other great dissents have, but I think it will have a role over the next few years as we see what the implications are of the majority's view. So thank you very much.
Thank you very much, James, for that very thought-provoking talk. Now, if anybody in the room has any questions, now is the time. This is an opportunity for you to quiz James and Reuben. If nobody has anything, the first question I wanted to ask James was, how much do you think the reduced margin of appreciation was related to the fact that this was an Article 2 claim as well as an Article 8 claim? And therefore it's not a qualified right. I'm thinking about it in the context of other areas where Article 2 claims, there are, it's an absolute duty to protect life, and there aren't the sort of fallback positions that there are under Article 8.
Yeah. I think that's a perfectly valid interpretation of what the majority have said. But of course, it's not the way Judge Ike sees what they've done. And it's obviously not the way that some of the people who've commented on the decision have seen that it's happening. But
what I suppose I'm saying is, isn't it interesting that they're using Article 2? Like, historically, the courts have been very reluctant, and including the European Court, have been very reluctant to use Article 2 for anything other than cases to do with crime and punishment, if I would put it that way.
It has crept into some of the other environmental cases that are existing, although, there was the one about the huge heap of material that collapsed in Turkey. But obviously that's an extreme case, isn't it? And people died. So
people did actually die.
Yes. But I guess I suppose it is part of why they ended up where they are, but the reduced leeway must apply to the whole of this right, which encompasses both Article 2 and Article 8. So it's going to have some implications. I mean, certainly there's fuel there for arguing a reduced margin of appreciation, at least in climate change cases, but I can't see it stops there myself. But
no, I mean, it could be any case. You know, I'm thinking about sort of healthcare cases when you're talking about sort of radical failures of healthcare for particular groups of individuals. You could see that becoming more of an issue if there's an imminent risk of death. You know, not vaccinating young people, something like that. Well,
and you know, environmental cases have kind of led the way in some areas and changed public law generally. You know, for example, in Aarhus costs, it became to be sort of, you know, well, hang on a minute, why is the environment treated in this way? There are other public law things which are equally or maybe even more important sometimes.
But it can also be used to, I mean, I'm just thinking about my road schemes where road improvements are often put forward for safety reasons, and they predict the number of deaths that will be saved. So presumably you can invoke.
well, you can have a
the
balancing
reasoning the other way.
exercise of the deaths the other way.
Yeah, quite.
For the additional I mean, quite how you do that. I mean, it seems to me that this is going to be a bonanza for kind of modelers. You're going to have all sorts of people coming out with sort of complicated models.
Those models have been around for a very long time, and it's much easier to prove causal connection to a death from a road accident than it is to a death from a couple of 100,000 tonnes of CO2.
Yeah.
So it's quite, from a court's perspective and a margin of appreciation, that presents.
And how can the court assess that? How can the court reach beyond?
And I mean, I was very interested as well, James, by your view about having an environmental court, because I'd written down, do we need to have an international climate court, as kind of one of my questions that I wanted to ask, thinking that isn't that an obvious thing that should come out of the relevant endless negotiations there seem to be in every COP.
Yeah, although, I mean, it's interesting, one part of Ike's dissent, which I didn't talk about, was he talks about the fact that Paris and some subsequent agreements that have been reached have much more focused on delegating all of the approach to coordination back to the member states for their nationally determined reductions. So it's actually kind of contrary to the kind of thrust of the most up-to-date climate. I think what he was saying was, you're actually going against the most up-to-date climate international agreements by kind of centralising this, because actually what's being done is it's being pushed back to the member states. I mean, there's been a campaign for ages for a World Environmental Court, which, you know, I don't think we're anywhere nearer than when it started. But I think, you know, if judges are going to have to make decisions like this, we are going to have to think about how they do it. And I don't know, you know, I don't think we're going to go to an environmental court model, but could we use assessors? You know, is that something that we could do?
At the moment, it would be nice to get listed in front of a judge in a planning case that's actually done some planning law at some point in their career.
Yeah, fair point.
So,
fair point.
I mean, the only way that that's going to change is with a significant influx of resources.
Yeah, which is not going to happen.
Judiciary, which isn't going to happen anytime soon.
No, it's not going to happen.
I wanted to ask another question, which is largely about Heather's talk. Do you think retrofit's a fad, and that everybody's going to go on about it in their policies, and then in a couple of years' time, everyone will change it and forget about it? No.
I don't. I think as we get closer and closer to net zero and to the huge reductions that are required for the 6th carbon budget and no doubt on into the 7th, these issues are going to be more and more and more and more.
I think I mean, I agree. I mean, I think it's interesting. I think one of the things that I've always loved about London is it changes so much, whereas other cities just don't seem to change. In London, you know, it changes so regularly. I mean, I think we're seeing buildings now that we saw go up in the 90s being pulled down. Whether that will continue doesn't matter, especially around here.
Sort of constant whirly.
Yeah, whether it's a good thing or a bad thing, I don't know.
I think what will change will be construction techniques that will mean that we have much lower carbon new build buildings, and that's what will enable that continual change in London. But that's going to take a lot of economic pressure to develop those kind of techniques and the materials that you'd need to do that.
But do you think, therefore, that those policies that are being adopted by London local authorities are therefore good in terms of if you're pro reducing carbon and the bigger emphasis on retrofitting?
I think it's part of creating change in the construction industry that is needed as part of our push towards net zero. If we're going to hit these carbon budget figures, then that's the sort of change that has to occur.
And it's retrofit first, as I say, it's not, you know, you can never demolish a building, but, you know, you look at that first, and I think that's good.
Yeah, okay. Do you think that any of the cases, Reuben, that you mentioned today would be decided differently after the Swiss case? Now, obviously, everyone has been very careful to say, including the council who represented the Swiss ladies, that it wouldn't probably have any impact in the UK because we have the Climate Change Act and we have various carbon budgets and we have lots of things which they did not have in Switzerland on the facts.
I think it might have changed some of the earlier cases, actually, the sort of just post adoption of net zero cases. So the Drax decision might have been different if you scrutinise that with a narrower margin of appreciation.
I mean, there was a human rights set of issues in the Heathrow case that didn't really get a lot of airtime. I think they would have been quite different if we, because I mean there was an attempt to rely on the Dutch case and stuff.
Dutch youth case,
but those might have had a different result. Because I mean, I think it was felt by a lot of people that those arguments were just over ambitious at the time, not just in that case but other cases. But are they over ambitious now? I don't know.
I mean, is there anything wrong? I mean, you've obviously talked about the model of the judiciary are not elected and therefore there is a democratic deficit. But the reality is if nobody else is doing anything.
Yeah, I mean, I accept that, but why are we stopping at climate change? You know, that's the problem.
Well, maybe because climate change has a more existential, the sort of 5 minutes to midnight argument is stronger in climate change than it is probably in any other policy area. And therefore you could say it must be treated differently.
Well, I mean, there is a problem, isn't there, that the changes that we require to make to battle climate change involve quite a lot of personal sacrifice, which people are never going to vote for. I mean, the majority of people are never going to vote for. And that means maybe those who are not democratically elected have got a better chance of actually delivering this. But there is that argument. There is that argument.
We've got a couple of questions in online. The first one is, to what extent has law made economic growth more environmentally friendly in the UK? I think
that's a
I think
tough
I
one.
can spy a kind of enthusiastic graduate or research student in that argument.
It depends what you mean by law, doesn't it? So, so if law means the Climate Change Act, and thus the move by the UK to meet its climate change commitments in Paris and the like, then law's played a central role in seeking to set up the policy framework that delivers a more environmentally friendly economic growth.
Well, we look at building regs, the change to building regs to make to reduce carbon impact of buildings. I mean, that's all through law, and it does, over time it makes a huge difference.
We haven't had any economic growth.
No, we haven't had any economic growth, but that's for a very long time.
But does anybody think that failure of economic growth is linked to the higher environmental standards that are necessary in construction or planning?
Certainly not the main driver. That's for sure.
It's a factor, but I'm not sure it's a particularly significant one.
And the second one is, if a road scheme provides a value on death, then can this be used in assessing the 0.2 trillion cost, 20% of UK GMP, in reducing the impacts of climate change, i.e. life saved or not? Article 2 versus a reduced value of a private life, Article 8.
Potentially, yeah.
Says anonymous.
Yeah, there is a means of valuing a death that is used and has been used for many, many years by government. It's not particularly savoury.
Is that not years lives lost? Because that's another one.
No, that's a different-
Well, you've also got something called a QALY, haven't you? Quality of life years, which is which they use sort of NICE and various other health bodies use that for kind of how long you live without being in severe ill health and pain.
It's amazing how inventive the economists can be.
Yes.
But yeah, in theory, you can use those sorts of measures and bring about these sort of monetary appraisals. I think the real issue is how helpful is that in decision making, which is essentially political at its core. I'm not sure it's all that helpful, because inevitably, if you reduce things into money, you leave things out of account. How do you value the impact on Stonehenge of the tunnel portion 2 miles to the south, or the impact of the A66 on the AOMB that it runs alongside? You can't turn those into monetary values.
No, and there's lots of things about sort of quality of life and happiness and all those sorts of things, which I know some economists do now value, but I know is quite difficult to value in any meaningful way, but which are very important when you're thinking about the creation of social policy. Okay, thank you very much for joining us today.